Hello, everyone, and welcome to Uncivil Law. For today's story, we have a story that was requested by someone in the channel in one of our comments, and I figured why not. This is the United States case of Patchak versus Zinke. This is a United States Supreme Court case from 2018 and effectively deals with the power of Congress to decide a particular case in terms of the particular outcome of a particular dispute. So, of course, Congress passes laws, and one of the laws they can do is pass things retroactively. The question is, can Congress, by changing the law during the ongoing dispute of something, change the outcome of a case that's ongoing? Can they direct the case to come out a particular way by operation of law, by operation of legislative fiat? So we're going to read the opinion of the U.S. Supreme Court and decide what principles emerge. Petitioner David Patchak filed suit challenging the authority of the Secretary of the Interior to invoke the Indian Reorganization Act and take a trust in a property on which the respondent, Match-E-B Nash-She-Wish, band of Potawatomi Indians, wish to build a casino. That may be the best party name I've ever seen. In Match-E-B Nash-She-Wish, band of Potawatomi Indians versus Patchak, this court held that the Secretary lacked the sovereign immunity and that Patchak had standing, and remanded the case for further proceedings. While the suit was back in the district court, Congress enacted the Gun Lake Act, which reaffirmed as trust land the Bradley property and provided that an action relating to that land shall not be filed or maintained in a federal court and shall be promptly dismissed. In response, the district court dismissed the Patchak suit and the D.C. court affirmed. So as we see here, there was a piece of Indian land and there was a question basically as to the ownership. This piece of land was in trust, and Congress decided to pass a law saying it's explicitly in trust and ordering a court to dismiss any lawsuit brought concerning the land, saying that the courts could not hear the case. So they are directing the outcome as it relates to a particular piece of land, in this case tribal land, by an operation of Congress. So Congress is saying the courts do not have jurisdiction over this. This is the outcome, end of its story. So the question is that legal? Held. The judgment is affirmed. Congress may not exercise judicial power, but the legislative power permits Congress to make laws that apply retroactively to pending lawsuits, even where it effectively ensures that one side will win. Permissible exercises of the legislative power and impermissible infringements of the judicial power are distinguished by the following rule. Congress violates Article 3 when it compels findings or results under an old law, but not when it changes the law. So the court here is saying, look, if there's a law already on the books, you can't change that law. That law is the law, and you can't direct an outcome. But as it applies to civil cases, not criminal, in criminal cases we would have ex post facto doctrine. But in civil cases, you can have retroactive laws. You can change the effect of things civilly going backwards. There's no prohibition against ex post facto law on the civil side, only the criminal side. So the court is saying here, look, you can change the law going backwards by operational law. You can't direct a particular result, but you can change the operative law. So that kind of makes sense as far as the Constitution is concerned. By stripping the federal courts of jurisdiction over actions relating to the Bradley property, this section changes the law. Section 2B is best read as a jurisdiction stripping statute. It uses jurisdictional language, imposes jurisdictional consequences, and applies notwithstanding any other provision of law, including the general grant of federal question jurisdiction under Section 1331. And while 2B does not use the word jurisdiction, jurisdictional statutes are not required to do so. Indeed, Section 2B uses language similar to the language used in other jurisdictional statutes. And Section 2B cannot be plausibly read as anything other than jurisdictional. When Congress strips federal courts of jurisdiction, it exercises a valid legislative power. This court has held Congress generally does not violate Article 3 when it strips federal jurisdiction over a class of cases, and has reaffirmed this principle on many occasions. Patchak's two arguments for why Section 2B violates Article 3, even if it does strip jurisdiction, that the provision flatly directs federal courts to dismiss lawsuits without allowing them to interpret or apply any new law, and that this attempts to interfere with this court's decision in a previous case that his suit may proceed are unpersuasive. So basically there, the United States Supreme Court is pointing out that in a prior decision regarding this person and regarding this case of land, there was a decision that his lawsuit could proceed. There was an issue as to whether or not he had standing and other issues. Could his lawsuit go forward? So the United States Supreme Court said, yes, your decision can go forward. And Congress was so upset about that, they passed a law specifically barring him from going forward. So the question is, can Congress change that result? And the answer is yes. The issue that gave him authority to bring this lawsuit in the first state was statutory, not constitutional. He had authority under the statutes, including jurisdictional statutes, to bring the case. And so Congress changed the statutes. They said, you can't bring this to case. We're going to deny you authority. And the United States Supreme Court said, yes, Congress can do that. They can change jurisdiction even as it relates to an ongoing lawsuit, even a lawsuit that we said that is able to go on, because Congress has the power to control legislation. Justice Ginsburg, joined by Justice Sotomayor, concluded that Congress's authority to forego or retain the government's sovereign immunity from the suit suffices to decide the case. As the name sovereign immunity implies, the government is generally immune from most lawsuits. To bring a lawsuit, you have to point to a statute that gives you the authority to sue the government. And there are quite a lot of statutes that give you the authority to sue the government. But these two justices said, well, this is an issue of sovereign immunity, and if they want to, by statute, say that you can't bring this lawsuit, they're just reclaiming their own sovereign immunity, which is something they can do. Okay? With Patchak I in mind, Congress acted effectively to displace the Administrative Procedures Act waiver of immunity for suits against the United States, which enabled Patchak to launch this litigation with a contrary command applicable to the Bradley property. Justice Sotomayor concluded that Section 2B of the Gun Lake Act is most naturally read as having restored the federal government's sovereign immunity. Justice Thomas announced the decision of the court and delivered an opinion in which Breyer, Alito, and Kagan joined. So that may be a bit unexpected. You got a little bipartisan split there, or a bi-philosophy split. So you got Thomas and Alito, pretty conservative people, and you got Breyer and Kagan, not so conservative. So you got people on both sides of this. So this is not a, 5-4 in the traditional sense. Sotomayor filed an opinion concurring in the judgment. So Sotomayor also joins. Roberts filed a dissenting opinion in which Kennedy and Gorsuch joined. So that is the end of the case of Patchak versus Zinke. What we learned here is that Congress has control of the statutes. Congress can change the statutes retroactively, at least as it applies to civil cases. In the context of criminal cases, retroactive criminalization is illegal because it's ex post facto. But that logic does not apply to civil cases as in here. This is a civil case because the operative question is, among many, who has title or proper possession of land. Here, the United States Congress passed a law specifically denying jurisdiction to the courts from hearing a particular case. According to the United States Supreme Court, this reaffirmed their judicial immunity, their sovereign immunity, and so it was a proper passing of statute, even though it effectively dictated a certain result. And this was a bipartisan case in terms of its outcome, so that is the end of Patchak versus Zinke.